Kathy, I hope you're doing well. We made it to Tuesday. Today's my Monday. Today I start my week of a lot of doubles. I got a lot of doubles this week. But we have a new show. So everybody's excited about it. So it should be busy this week. I hope. I hope. We have three types of people that come to where I work. Regular, normal people who just want to come and see a show and pay the price and come in. And then we have two different tour groups. One is where they pay a price and tip is included in that price. Darn it. And the other is elderly. So just elderly people, bus tours. We get those every day. Like huge bus loads. They get like a discount on the ticket price, I think, and they get a special menu. And we don't put comment cards on their tables ever. I put comment cards on every single table, and encourage them. Let us know what you think. Let us know that those other buses never get a comment card because we already know what they think. We already know the food is not hot enough. We already know it's too cold in here. We already know the service is slow. We already know what you think. So they don't get comment cards. I'm hoping we don't get a lot of them this week because they're just so hard. They run you ragged. Can I have another water? Can I have a different lemon? I swear the very first table I had last week was a six top of this bus group. Two of them returned their drinks right away because there was too much ice in it. And let me just tell you, there's not too much ice in it because here's how I know there's not too much ice in the drinks. Because we pour the drinks 30 minutes easy before anybody walks in, and we set them up on a big station. So that way, when 150 people walk into the dining room all at the exact same time, all the drinks are laid out. So we just get the order, go back, get the drink, take it to the table. The ice doesn't last 30 minutes. It just doesn't. It doesn't. So I get like 5, 6 tops in a row. They all come in, they all sit down from this bus. And I have to get all their drinks right away. The very first table I get to, I put the drinks down in front of them. 2 of the ladies were like, there's just too much ice in here, right? I still have to get 4 other tables' drinks before I can fix this huge error. So I get the second table's drinks and I take them to the table, and the ladies at the first table, excuse me, can you get our drinks? I'm working on it. Then in the third table, I bring their drinks out. Excuse me, are you gonna get our drinks? So I walk over to them like, guys, I gotta get their drinks first. I'll fix it. I gotta get their drink. They don't even have a drink. They don't have a drink at all right there. The people you're on the bus with, they don't even have a drink. So just let me get their drinks. Yeah, but you know what? I bet you, Kelly, by the time I actually did get their drinks out to them, their first drinks, ices have already melted. And the joke's on them because all I did was take 2 more drinks that are already set up from the same table. I brought it out because the ice had already melted. Even if it's water. Yep. But they're like that. They're every day they're like that. They're spoiled, they're entitled, they're rude, they're obnoxious, and they want every single thing they can get you to go and get them. They can't just order a drink, sit down, eat their meal, and drink their drink. That's not in their playbook. They don't even know how to do that. Then they ask me things like, it's a buffet. So they ask me things like, can you, get more blah, blah, blah. No. They'll bring more out. If it's out, they'll bring more out. You're just going to have to wait. I'm not going to get it. No, I'm a server. I'm busy. Or they're like, can I have chicken without that sauce on? It's a buffet. The food is already prepared right there. That's what you can have. Just go and get the food and eat it. And I know when they were growing up, like, they ate what was in front of them. I know it. I know when they sat down to dinner at night with their mom and their dad, they ate what was on their plate. But, yeah, we don't give them comment cards. I would like to put out comment cards once, just to see if they'll take the time to write down everything they hate about this place. The show's songs stink. They just go on and on. But whatever, they pay the bills. We get a lot of those buses. They keep the place going. What are we doing? We're doing a new judge. This will wake you up. It's going to wake everybody up. This only lasts for a minute or two. But check your volumes.
Be applied any damages that are assessed, but that's, just understand the law on those two things.
Yes, sir.
Can he lock the residence? I don't have any keys.
We will do December 8th.
Next hearing will be December 8th at 1:30. You're both excused.
The house is not locked. There is no, he took the keys. So anybody can walk.
You'll get the order of possession in the mail, and if you have any issues locking it or whatever, you can contact the sheriff's department. But that'll be in the mail.
Thank you.
I don't know any more than you know right now. I do not know. I think she got incarcerated and lost her apartment, and this was the landlord-tenant hearing. I don't know. I don't know what's going on, but that's how we're starting today.
Okay.
Peter Donahue versus Martin Trainer. Files number 406004, 2509 EV 1916.
Wait, this isn't a new judge. We know him.
Who's ever going to testify, they could raise their right hand.
I think we're in Indiana.
Do you solemnly swear or affirm on the pangs and penalties of perjury, testimony you're about to give today should be the truth, the whole truth, and nothing but truth?
I do.
Yes.
You are, sir, in the green?
Peter Donahue.
You're Mr. Donahue appears in person. Martin, oh, I forgot. Oh, Katie Anderson. Yep. What am I doing all this for? All right, Peter Donahue, you'll go first.
Okay, Mr. Trainer had a lease with me. Ran through May. He stopped paying rent. I could not contact him. He did not respond to texts, and I could not get a hold of him whatsoever. He had paid rent, but then he did not pay rent. His attorney called me up and said, hey, he'll pay rent with the late fee, and he did do that as of October 10th. He said he'd be out of the place, and he is out of the house. But now we had this case already set up. This is what prompted that by having to evict him. So now we are here. But he is out, and I've had to do the maintenance. I had to get into the house to see it, and there's quite a bit of damage.
But the only thing we're here on today, though, is eviction. Yeah.
Correct.
Yeah, okay. And you have possession?
Yes.
You have vacated?
Yes.
Anything else I need to know?
I would just request that, if we are, saying he's out, that the lease would be terminated with no further rent due.
Oh, yeah. As far as well, the actual rent and any kind of damages will go back to whatever happens when you come back for the damages hearing. And at that point, at the damages hearing, just like you heard in the last case, you need to come to court, whatever, if there's any back rent that's due, gotta have that, gotta have any kind of damage to repair, stuff like that. Pictures, evidence you have, he certainly has the right to refute all that, and then the judge will make a decision on damages, but
Fair
as
enough.
far as today's order, stipulation of parties is that, respondent has vacated, plaintiff has possession, manner will be set for damages hearing on
December 8th.
December 8th
At
at 1:30 PM, right here. You understand all that? I know, fast,
And
but she
ju-
understands from time.
I was gonna say, just
Maybe,
clarification though,
Bobby.
so the lease
Maybe, Bobby, maybe. You know how. So, this hand right here is on this side of me. You know how when you record things, sometimes they get flipped when you're. So maybe the flag's on the wrong. No, it can't be because look, it says judge. Bobby, you're right.
is considered terminated and there'd be no future rent due because he has vacated and.
Well, from what I've heard, and given the looking at the lease, which I don't have a copy of the lease, do I? Hmm?
It wasn't included.
It wasn't included, okay. When did the lease expire?
The end of May,
End of May.
2026.
So, yeah, so the answer to the question is that he has an obligation for rent up to May 31st. No, that's May 21st, 2026,
May 26th, or yes, about May.
but 2026?
Yes.
Okay. So to answer your question, I'm sorry, I misunderstood that. The answer to your question is yes, the lease is terminated as of today's date, day of, well, he already has, when did you gain possession?
October 10th.
So lease was terminated then effective October 10th. Okay, that answers your question?
Yeah, so, well, I guess, just to clarify, he does not owe
There was
rent.
no rent after October 10th.
Fair enough.
Damages, we got that December 9th,
December
1:30 right here,
No, December 8th.
December 8th.
You wrote that down for me.
So is that little
Nothing.
sheet green, is
Oh.
there a pen there?
Thank you.
Is there a pen on that table? I don't even know.
Pens become a hot item. Nobody
Well, the
uses.
prosecutors sit at this table, so that's why they might not have pens. There is, okay.
So the date again, please.
December 8th at 1:30.
Right, both excused, thank you.
Thank you.
Why don't the prosecutors get pens? Do they eat them? What's going on?
Thank you. That was much smoother than the previous one.
Thank you.
Tall Timber Apartments
Hi,
and Jennifer
Dennis.
Kuta.
Oh gosh, he did say north, didn't he,
Kick him
Kelly?
out, he'll go
I know
first.
it means up.
Just kidding.
It means up.
Tall Timber, anybody here for Tall Timber?
That's me.
Oh, you're here for Tall Timber, I'm sorry.
It's okay.
Jennifer Kuta? Jennifer Kuta? Jennifer Kuta, all right. I guess I probably should swear you in, and paying penalties of perjury, the testimony about to give us be the truth, whole truth, nothing but the truth.
Yes.
All right. Records reflect, first of all, 12 Timbers Apartments appears pro se, and that Jennifer Kuta does not appear. Record will reflect also that on September 24th, 2025, Sheriff's Department reports that service was perfected. So, and the respondent fails to appear. So what do I need to know?
As of today, Ms. Jennifer has not vacated the property. And she currently still owes us a pretty substantial balance, so we are asking for immediate possession of her unit.
What is she name? 5 days, 10 days.
Usually 10, but it can be quicker if you find that.
All right, Based on testimony, court finds that petitioner is entitled to possession. Possession will be effective October 25th by 5 p.m., which is a Saturday. So more realistically, let's just go ahead and say October 27th, because you're not going to get anything on a weekend. October 27th by 5 p.m. she is to be vacated, and if she's not vacating, you can call the sheriff's department with the order and they'll help you with that. Damages hearing is set for December
December 8th.
8th at 1:30.
Got it.
And bring whatever you got then. Tall Timber Apartments, pro se, versus Ashley Lemons. 4060042509 EV 1888. Tall Timbers Apartments appears in person. Ashley Lemons does not fails to appear. Record reflects service on the respondent on September 21st, 2025. And we've had no contact with her. So what do I need to know?
Same exact thing. She's still at the property, hasn't left, and still owes us pretty penny.
You're still not getting run. All right, court's order is that exactly what I said before. Plaintiff is entitled to possession. Possession will be effective on October 27th at 5 p.m. Plaintiff can call the LaPorte County Sheriff's Department. LaPorte County Sheriff's Department is under an order to assist the plaintiff in the event there's any difficulty of Ms. Lemons vacating the property, which shall be the possession of Tall Timbers October 27th. Oh, that was easy. Have a good afternoon.
You too.
You know, I thought maybe it's just band handwriting here, but I know it's exactly S-Tech LP. S-E-S, is that what?
Yes.
Yes, Tech LP. Says he's appearing pro se. What are you doing here?
Well, I was here, so he just said, stay.
It comes in at the damages.
Yes,
She usually comes in at damage time, but she's doing this early.
I happened to be here today, so
S-Tech LP versus Emma and Justine.
Debbie, go to bed. What are you doing up so early? It's still dark outside.
Is there an Emma and Justine?
Your Honor, we actually have possession of that one already,
Oh, you do?
Yeah.
So
so just need it set for damages.
December 8th, and
Is that,
That's
are
fine.
you okay for?
I think so. Let me double check.
for the record, ES Tech LP appears in person and by attorney Saul Matthews. Reports plaintiff already have possession of the property. Matter now set for damages hearing on
I'm good.
December 8th at 1:30. So I need to ask before you, oh no, I can ask it for the next one. While we're writing things down, what is S Tech LP?
It owns most of our properties here in LaPorte County.
What does it stand for, AS Tech?
It really stands for nothing.
You know,
The name we created 25 years ago.
I've been reading stuff online about the new thing in junior high schools of 6-7, which
Linus.
apparently
Thank
has
you,
no
Linus.
mention or
Thank
no
you.
meaning in anything at all, so we can put S Tech in the same.
There's initials, but yeah,
The name of my corporation is, from my office building, is Ted Canaris, which was the story, my father was a great storyteller but you never knew how much of it was true or not true. But his story was, his version was, he grew up in the sandlots of New York and played baseball, and he was such a good baseball player. He was often pitching for some of the sandlot teams. And because there was an age limit, he was younger than that, and he didn't want my grandparents to find out about it, so he said his name was Ted Canaris instead of Ted Saranac. And Canaris is Saranac spelled backwards, so that's the name of my corporation.
there you go.
We are back to S Tech LP versus Yvonne Ortega and Christine Smith. Well, they are here. This is 4060042509 EV 1901.
Linus, that was epic. Debbie, you're green. Linus, that was epic. Thank you.
Anybody who's planning on testifying, I'll let you sit down
Who
first.
did you do that to once? Was it Sue Gray? Remember you gifted one membership and we were all trying to get this one person for weeks green? Was it Sue Gray? Is that who it was? Oh, I wish I could remember. Oh, it's right here. We were trying to get this one person green for weeks, and everybody kept gifting memberships. And then Linus walks in one day and gives one membership, and boom, that person is green. I think it was Sue Gray, but I'm not 100% on that.
Anybody who's planning on testifying, please raise your hand, right hand.
Judge.
You promise or you swear or affirm to tell the truth, the whole truth, nothing but the truth, and the pains and penalties.
Yes.
Yes.
Don't help me God.
All right. Okay, I'm not allowed to ask that anymore, but that's fine. Okay, I'm not allowed to ask it. First Amendment stuff. Okay, your name, sir, for the record,
Jeff Stricker.
and you are,
Yvonne Ortega.
and you are Christine Smith. Okay, all right. Ms. Paul Matthews.
Mr. Stricker, what is your affiliation with ES Tech LP?
My wife and I are the limited partners.
And are you familiar with Christine Smith and Yvonne Ortega?
Yes, we're tenants at 120 Poplar Street.
And did you have a written lease agreement with them?
We do.
And when did that lease agreement begin?
It began on July 1st of 2023.
And when did it expire?
The lease itself expired on June 30th of 2024.
And has it been renewed?
It has only been renewed with our permission on a month-to-month basis, based on our lease under the holdover by leasees.
And what is the monthly rent that they're paying?
$1,495,
And how many months behind are they at this point?
September and October.
So are you asking for possession of the property at this time?
Yes, we are.
That's all I have for Your Honor.
Thank you.
Your Honor, may I speak?
Well, let's just go one at a time here, but, yeah, just go ahead and tell me what you want me to know.
Well, the reason that the rent is behind for September and October, my mother moved out last November. So then her income was no longer there, so I would stop paying her portion, my portion, and then the rest of the remaining bills. My little cousin, who also was living with us, who has disabilities, he was living with us because he is very highly autistic and he is supposed to have constant supervision, so he was under my care. He was caught stealing from me and he had to move back in with his father.
Thank you for the cheers, Kelly. I missed
And
that.
I
Thank you.
contacted Jeff in September, the very last Monday of September, and he asked me when I would be paying September's rent, and I said I would be paying it on Friday, which was the last Friday of September. Tuesday morning, I came home to the eviction papers on my door, already starting the eviction process. So I wasn't able to pay September's rent because he already started the process before I could get paid. My pay periods go, I literally get my hours approved weekly. I work Thursday through Monday and I work 17-hour shifts. I have to wait for my bosses to approve each pay period. After they left and he's seen the eviction notice, he literally started the eviction process on September 28th. The papers were right there on my doorstep. There was nothing I could do. October came around, within 3 weeks that I'm supposed to try to figure out a place to move, coming up with $3,000 versus allowing me to pay the late fees, which all the late fees were included with all the other two incomes gone. I was struggling. I'm a few car payments behind to make sure he had his rent. And due to the process of everything financially falling upon me by myself, no help with none of my kids, I don't have help with my nothing. I'm strictly the only one paying everything by myself. So that is why the rent has not been paid. And he started the eviction process at the end of September. We got here October 20th.
Let's just hypothetically say that the eviction process starts today.
Yes.
And he's testified that I think that you're behind 2 months.
Yes, I am.
And you admit that.
Yeah, absolutely.
If you came to court, do you have the ability to pay those 2 months?
No, I am not. I have been paying out fees for applications for apartments and $50 application fee, non-refundable, $25, $45. The finances are kind of a little strenuous.
Sure, I understand.
Because I wasn't expecting him to, evict us all of a sudden, even though all the late fees were paid. And the rent that we were paying was actually wrong. We were paying $15.55 a month, plus an additional $60, which was every time it was late, I paid all the fees. Which the last payment he got was $1,705 because it was so late.
If I were to, and the courts shouldn't do this, and of course I shouldn't do this either, but let's just say, for example, that I were to say that everything you're saying, I believe, and of course I do. And everything he was saying was not true, which I'm not saying that.
Right.
based on what your testimony is and based on the fact that he had that we both agree, or both sides agree, it's his unit.
Yes,
and-
absolutely.
And he owns it and
Yes.
therefore he was leasing it out pursuant to the terms of the lease.
Yes,
Under the operation of law, he's entitled to possession.
right,
He could be the biggest creep in the world, he could be the biggest liar in the world, but as long as he's right on those two things, it's his property and he's allowed to go forth and the law would support him on that.
I'm,
So what the court is gonna do today is order you to be evicted within 10 days from today,
Okay.
which puts us at October 30th at 5 o'clock PM.
okay,
And you need to have all your possessions out of that, and make sure the keys returned to him, and then we'll come back for damages,
okay,
which will include, of course, he'll have right to possession then at 5:01 on October 30th. And he'll be able to go in there, and then at that point, he can start assessing any damages to the unit. And he'll
Monica,
also be able
thank
to come
you,
back and say
thank
this is how
you.
much rent you, or back rent you own on top of that, and then the
Right.
court will issue an order on damages. That damages hearing is set for December 8th at 1:30 PM.
okay.
Okay,
All right, thank you very much.
thank you for appearing. And nothing personal about the fact that I don't believe a word you're saying that you're a liar. Just was irrelevant to your deceptiveness is not important. All right, Clarence Hovey versus Craig and Jockey, how do you say it? Huh?
It's really just me. She ain't been on the leash.
You got some good ones.
Who are you?
I'm Craig.
You're Craig.
Yes, sir.
Where's Clarence? Oh,
I'm his son, so
there we go.
What
Okay.
videos?
this is his
I don't
daughter.
know what videos you're talking about.
All right, so anybody who's gonna testify today, raise your right hand, please. You promise to affirm to tell the truth, the whole truth, nothing but the truth, under the pains and penalties of perjury.
Yes.
All right. Plaintiff, so for the record, what is your name?
I'm Clarence Hovey the second. And this,
I'm his daughter, Jackie Griffin.
Who owns the unit?
my father, he's elderly, he can't come in.
You can't, so you're here on his behalf?
Yes.
All right. And you are Craig and
Yeah.
what is your name?
Jaquise.
Jaquise,
Yes.
thank you. Right, all right. Plaintiffs, go, your show.
Your Honor, our father rented this to them. It'll be a year in December. There is so much damage. I have pictures.
We're not doing damages today, we're only doing, the only issues before the
Yeah,
court
well-
today is eviction and possession.
And then the rent's behind, and I mean, we got a text from him stating that he's gonna ride it out for the full extent of the law, so.
I'm sorry?
I said, then we received a text from him once he got the eviction that he's gonna ride it out for the full extent of the law. So,
The water shut off.
yeah, and the water, I do believe has been off, I mean, last time we checked.
Ain't no water cut off.
It's not going off.
Look at your turn.
Oh,
Understand that
sure,
I am very hard of hearing,
all right.
and it's hard enough for me to hear one person talk, much less more than one person talk at the same time.
The last time we received a bill, the water was on,
Wow.
so I don't know if you got.
My,
back.
my dad called and the water was shut off. That was a concern of his.
The question that I'm just asking though is the fact you have a leash.
Yeah, and he's behind.
Oh, for how much to be paid a month?
$1,200 a month.
Okay, and are they current on their rent payments?
No.
Approximately how far behind are they?
2 months.
2 months. Anything else I need to know on that issue and that issue only?
I don't hear that good.
No,
And again, I don't wanna get into any of the stuff on their garbage landlords or anything like that. I don't care about that. That's for a later date. Somebody.
Oh my gosh, I'm so sorry. I'm so sorry. Oh my gosh. Oh boy, did I mess up big time. Happy Veterans Day, guys. We have a ton of veterans in here. I am not a veteran, but I know a lot of you are. And thank you. Thank you very much for your service. And I hope that you have a happy Veterans Day. And I hope that everybody who you see thanks you today.
Else can get here.
Only eviction.
Only here for eviction. You agree that's their unit?
Correct.
Are you behind in rent?
Correct.
That's really all we need to do. Anything else I need to know?
I'm not even on an active lease with them right now.
You're what?
I'm not even on an active lease with them. My lease was signed in 24/12. to the 25. We were supposed to do sign another lease. We never got to sign the lease with them to this lease. The rent that I'm behind, they agreed to meet to rental assistance. They agreed to it right here, letters that they signed, she signed, written. A week later, she filed the eviction process because her father didn't want to wait for, rental assistance to take 60, 90 days it could take. So with the rental assistance, they didn't want to wait for the rental assistance. I got the paper, signed the paper, she signed the paper, all that. 2 papers right here. One she wrote, one that I wrote, she signed. That gotta go to the rental people and
Let me see those.
and they denied that after a week, after she asked me how long it's gonna take for her to get her money, it was over with.
There's more to that.
Linus, thank you. Thank you, Linus.
Who's Jackie Griffin? Is that you?
Your Honor,
Are you Jackie Griffin?
Yes.
I don't hear that good.
You're in the same boat I am. Is your name Jackie Griffin?
Yes, sir.
Okay. According to this, and I just need to understand what you meant by.
Sir, can I please come up there? Because I can't hear you.
Please. Believe me, yes, I'm very sympathetic to that. Empathetic to that.
I'm sorry, I don't hear that good.
Neither do I. See, good hearing. But they only work up to a point. What does this mean? Once the eviction process is started, it would be stopped. What does that mean?
He printed that.
Okay,
She signed it, so she agreed.
Excuse me. He sent me a text asking me, I need to get rental assistance help because Jacquees left. She cleaned out all of our accounts. I don't know where she's at. I have that in a text message.
Okay.
I can't bring my phone.
did you sign this?
Yes,
Okay, and what is your understanding of that?
I didn't hear
What is your understanding of that?
that he was getting rental assistance and he was supposed to give it to my dad.
Okay,
He got the rental assistance. My dad didn't get a dime.
They pay right to, the rental people pay right to
you're gonna come closer so she can hear you.
The rental-
Look at her.
the rental people pay they don't pay me. They write the check straight to the landlord. They don't,
She's saying she never got it.
they probably ain't, they tell you it's processing. The process of from 30 to 60, 90 days is up to them. That's why they didn't want to wait. Because after they say how long the money it'll take.
Okay.
That's what my whole thing was, how long will it take to get dad's payment? That was the whole thing. I can't give you something that the rental assistance telling me,
I hear you.
you know what I mean?
Yep.
They got funding, but they saying that it could take this to this to process. And after that, that's when they did that.
Well,
All right, that's all. I've heard enough. You both, yeah.
okay.
I've heard enough. Again, the same thing I've said to everybody else. You know it's their property, and you know you're behind in rent. They're
Yeah, Zach. How cold is Florida? Please tell us. 50? Is it 50? Do you have to wear a light sweater?
under no obligation to accept rental assistance. It's kind of a voluntary program. Courts always try to enforce that or try to encourage landlords to accept it for the very same reason of what you're saying and what we both are understanding. But they're under no obligation. Law doesn't require that they set that. They can even say they will accept it and then change their mind 24 hours later. They can accept that all the way up until the day they walk into the door, and this hearing begins, and then they change their mind and say, nope, we don't want to do that. They owe us money. It's our unit. We want it back. And under the law, they'd be correct. And that's really the end of that argument. Now, having said that, we're going to set this for damages hearing. Well, we're going to ultimately get set for damages hearing. That'll be on December 8th, the same as all the other ones. If between now and then that gets caught up to date, that will have either one or the other type of an impact. Because when we come back for damages, they'll come back and they'll look at the unit and they'll say there are things that are broken and they're bad, stuff like that, and we want to ask for, took us this much money to clean it up and fix it. That'll be part of the damages. But also part of the damage is going to be back payment of rent. So when I said before, there's one of two outcomes that could happen. Okay. One is the rental assistance program pays on the back rent and gets you current on your rent. And then at that point, they say that's fine and dandy. We'll dismiss the eviction process and they keep living there. On the other hand, they'll come back and they'll say, We don't care. We still want possession of our property. We want them out, which under the law, that it's their right to be able to do that. What I'm gonna do for today is that I'm gonna say the same thing to you that I've done the other. Call those rent assistant people and tell them to do what they can and get them payment before October 30th, because you're facing eviction on October 30th at 5 p.m. So you need to be out of there October 30th on 5 p.m. unless they change their mind, they accept the pay, and then they tell the court, no, we're gonna do that, and that's fine. But everything is in their part at this point, not in yours. Understand me?
Yeah, I'm really cool with it, like, I'm already moving out.
Okay,
Good.
okay. That'll be this court's order then. Find plaintiffs for entitled possession effective October 30th at 5:00 p.m. Damages hearing for December 8th at 12:30 p.m.
1:30.
1:30?
1:30.
1:30 p.m. I'm sorry. Thank you for bearing with us.
1:30.
Thank you.
When is the court date, sir?
December 8th.
December 8th.
December 8th to 1:30.
Thank you.
Thank you. We're done?
If he would have paid up, it'd have been no problem, but he got like 11 windows busted out too.
Well, that's awkward. Okay. That's it. That's the end. I thought it was well longer. That's me not having my stuff together. That's me talking in a DM. Eek. I don't know which one to go to. All right, we'll go to this one, and if it's... What is this? I didn't know I had this from the 14th. Well, let's do this one. I didn't even know I had this one. I don't know if we did this one before. This ought to be good. This ought to be good. Did we do this one where she was wearing a scarf? Oh, no. No. We can't do this one.
In the wilderness, from the juror standpoint.
So,
Oops. Here we go. She did this sort of weird sort of trial sort of thing, but I haven't checked to see if I got the end of it. So there's no use playing a trial in Blanco's courtroom if I don't have the end. And I don't think I do. So we'll probably never see that one.
with a $50 cash
This is
option.
a new judge for us. In Boulder? Hold on, I gotta move our chat. Boulder, Colorado. So, we'll see how good she is. We'll see if we want to get more of her.
Mr. Giovanzana, if you're able to pay that $50 to get out, part of the conditions of that bond are that you not have contact with the victim or residents, that you report to pretrial services. The court would allow a civil standby for you to get belongings if you have any belongings, but you cannot go over there without the police. You are not to have any weapons and continue any mental health treatment or medications if you are on any of them. The court is going to set your next court date will be
We're gonna do
November 13th.
13th is my.
13th at 8:30 in Division 11 in Longmont. The other case number, do we? Excuse me.
What the hell do you mean you can't deal? You are from Pennsylvania. I don't understand. It's 40 degrees. If you were in Pennsylvania and it was 40 degrees, you'd be swimming right now. How can you not deal? How long have you been in Florida?
Is the public defender's office representing him in that other case right now?
Yes. They're working on it.
You've applied and you've applied in that case and they're representing you?
Your Honor.
Mr. Zamora.
So I believe I looked and checked over. We have his application. I think our admin is just checking for a few more things. So once you get out, just call our office. They might just need a little bit more pieces of paperwork from you. But we do have an app from him in that case, and it looks like it is our intention to defend him there as well.
Okay, thank you. All right, the court will set your court date for that next date and time, which will be the November 13th at 8:30 in Division 11 in Longmont with your other case. And you.
I don't think if I moved to Florida, my blood would thin in any amount of years. Here's why. I went to Catholic school. You know what that means? That means at first, when I was little, went to grade school, I waited at that bus stop we had to wear these jumpers, so my legs were completely exposed every day, every single day. I remember kneeling on my book bag, putting my skirt around me to try to get my legs a little warm from the cold. And then high school, I walked to school every day in my Linas, in my uniform. So my legs are completely, immune to cold. And then when we went to school, we didn't have heaters or air conditioners in the Catholic schools. We just didn't. So we were just, the weather was the weather, and that's how we went to school. So I don't think that we did have heaters. We had radiators. We didn't have air conditioning, that's for sure. But we did have radiators. I remember because McCaskey put tuna in our radiators one year because tuna tech. So at a certain point during the year, Catholics don't eat meat on Fridays, on Wednesdays. So they called us tuna tech. So one year they put tuna in our radiators, and I bet you can still smell that. I bet you can. The smell was unbelievable. But yeah, we were, if we did have heaters, they were not turned on much, because I remember cold in school, except in the summers when it was unbelievably hot.
You did receive a copy of that mandatory protection order?
I have one, yes. So those cases are combined then on the 13th, correct?
Both of your cases will be addressed. They're not combined, they're two.
Dude, I got 3 days in school suspension. Was it in school? I can't remember now. I got 3 days suspended because I wore a rounded collar, under your uniform you had to wear a white button-down shirt, and I wore a rounded collar instead of the regular collars. 3 days suspended.
Separate cases, but they will be heard at the same time, okay?
If you don't mind sharing as well, what's the difference between the PR and the other bond you mentioned, the surety bond, just so I'm familiar? If you wouldn't mind explaining
A
that, please.
PR bond is something that you would just be able to sign and get out without paying. The court has put a $500 cash or surety bond or a $50 cash bond. So if somebody is able to post that $50 for you to get out, then you would be able to get out.
I have $50 on me. Am I okay to say those myself?
I'm not sure how that works in terms of posting a bond, but if you're able to post that bond, then you would need to make sure you follow the bond conditions that the court just set, okay?
Yes, ma'am. My only other concern here, I'm looking for work currently. If I have charges that post online and people like employers look those up, it makes me a much weaker candidate. So I just wanted to see if there's a service you guys offer or something similar that would allow me to, be competitive on the market.
I can't help you with that, and I'm not sure, you'll have to talk to your attorney, and I'm not sure if they're able to help you with that either. But these are pending charges, and it is what it is. So we
No,
will see you
your attorney
at the
can't
next
help
court
you with
date,
that.
okay? All right, thank you.
Leg warmers were epic, CJ. Micah, if you can hear us, go to bed.
Court calls 25M2378 People v. Sandra Salazar. Ms. Salazar appears in custody with counsel. Ms. Mason, your position on bond.
Your Honor, I have no objection to a PR bond.
Do the people know where the children are right now?
Your Honor, it is our understanding that DHS is involved, so I'm not sure where they are at the moment.
Your Honor, they are currently with their sister at a different residence.
Okay, oh, I see them in the gallery. I'm sorry, are you?
My name is Devin Simmons with Boulder County DHS. Yes, the children are with her sister.
Okay, and there is a pending case right now?
Correct.
Okay. All right. Ms. Salazar, did you receive the protection order in this case? Okay. The court is going to find, based on People v. Zoller, that the no contact regarding the children at this time is appropriate in this case. Ms. Salazar, you won't be able to have contact with your children, but you need to cooperate with DHHS. The court would reconsider, but there needs to be some progress made and some safeguards put into place. And so at this time, the court is finding that a no contact order is appropriate. And also part of that protection order is that you are not to possess or consume any drugs or alcohol. The court is going the court is hesitant to set a PR bond. But it looks like you have some things you need to work on. So the court will set the PR bond with some non-monetary conditions. Part of that PR bond is that you not have any contact with the victims, that you cooperate with DHHS, that you not possess or consume any drugs or alcohol, that you report to pretrial services, okay? That you do that within 24 hours of your release. And that you will be monitored by pretrial services for sobriety. If there is any mental health treatment or medication for you to continue those, and the court will put that there's no contact except for allowed in any JV case if filed. So at this point, we'll see you at your next court date, which will be December 4th at 8:30 in Division 10. That will be over at the county courthouse on 6th and Canyon. Okay. And you'll need to apply for the public defender's office. When you're in custody, they will represent you, but when you come out of custody, you need to apply to make sure that they can help you with those services, okay? Alrighty, and then also please be in contact with Department of, with DHHS.
That was so gross.
Okay?
Oh my God.
Oh, I'm sorry, 2,500 PR bond.
I'm so sorry. I did not know she was going to do that. I am so sorry.
Okay. All right, we will see you. Oh, shoot, see you at that next day and time. Alrighty, court calls 25M1174, People v. Sierra Santoya.
That is her on the
Good afternoon, Your Honor.
Okay, good afternoon, thank you.
Address bond, if there's a way that my lawyer could address bond as well today.
We are gonna address bond in this case, Ms. Santoya. Miss Mason, position on bond.
Okay.
Your Honor, I note that the charges in this case are M2, and I'm unable to make a 16-4-115 record, so I have no further record.
Mr. Zamora?
Your Honor, I'd be asking for a PR bond, given the charges. I think that statutory, entitles her to a PR bond. I also want to make note that she is being held for the probation case, so even with the granting of a PR bond, she wouldn't be released today until she's seen on that one. So I think just given those facts, I think a PR bond would be appropriate here.
Does she have a total of 3 cases?
Two older meetings that she's being held on, this case that we're talking about, and that this hearing.
And so I was referencing the detainer case.
Okay. Okay, the court will issue a $1,000 PR bond. Part of the conditions of that bond is that she not have any contact with the victim, to report to probation within 24 hours, no alcohol, no drugs, and to stay away from Walmart. Next date and time, please.
We'll do December 8th at 8:30.
December 8th at 8:30 in Longmont. That's Division 11. So Ms. Santoya, your bond in this case is a PR bond, but it looks like you're being held on other cases that the court are not before the court, okay? So, and then if you would like the help of the public defender's office, you'll need to apply for them, okay?
Well, Your Honor, if she is remaining in custody, then our office will
Automatically.
Yeah.
Thank you. Okay, if you remain in custody, then the public defender's office will automatically represent you. Okay, so your next court date is going to be December 8th at 8:30 in Longmont in Division 11. All right?
Well, that happened. Oof.
And Your Honor, just before he gets here, we will have a disposition in that case.
Okay, thank you. I'm just gonna call this FTA really quick. 14 CR 46 and 25 M2368, People v. Jason Dockweiler. Mr. Dockweiler was on bond, has failed to appear. In the 14 case, bond was set at a $5,000 personal recognizance bond. Ms. Mayfield, your position on bond?
I would ask that the court just convert the PR bonds to cash or surety bonds.
Thank you. Court will find that he failed to appear, issue the amount in 14 CR 46 to a $5,000 cash or surety bond.
Public defender's not going to speak on that.
Conditions of that bond is to not have contact with the victim. Pretrial services, report within 24 hours. Continue any mental health treatment. No weapons. No drugs. No alcohol. And in 25 M2368,
Glad she called this one real quick, she said.
the court will convert that to a $1,000 cash or surety. Conditions of that bond is to not have contact with the victim. no drugs, no alcohol. Pretrial services, report within 24 hours. Continue any mental health treatment. And stay away from peppercorn. The address is 1,
What is
2,
peppercorn?
3,
Go to
5,
Peppercorn.
Pearl. CCIC only, 48-hour no. Do we have, oh, I see, Mr., okay. Court calls 25M1439 and 25M1108, People v. Sean Aarons.
Yes.
Thank you. He appears in custody via WebEx with Mr. Zamora. Ms. Mason for the people. Ms. Mason, what is the plea agreement in this case?
Yes, Your Honor. Can you hear me better now?
Yes, thank you.
Okay, I apologize about that. In 25M1108, the defendant will be pleading guilty to the original count 2 of public indecency for 10 days of straight time. And in 25M1439, he will be pleading guilty to an added count 3 of a drug misdemeanor 2 of unlawful use of uncontrolled substance for 30 days of straight time, concurrent with 25M1108.
Mr. Zamora, does he have any credit for time served?
Yes, Your Honor. And so I can say affirmatively he has 19 days credit as of 10/10 when the arrest report came in and the warrant was canceled on this case. Where it gets a little bit unclear is that on the minute order by Judge Lindsay on 9/28, the court, acknowledges that he was in custody in Jeffco at that time, and that's when the writs were ordered. But it's unclear from the record if he was actually arrested and held on these cases at that time. And so if he was, I would argue that he does have the full 30 days to close with time served, but just because when it says the arrest report comes in, it's unclear.
I saw Steve Tyler too.
How long he was in custody there. I can only say as of right now with 19, unless, the court is inclined to take that minute order of saying that he was in custody and give him the time from there as well, when he was held originally.
And is it 19 days on both cases or just one?
Yes, Your Honor, from the arrest on October 10th.
Is he being held on any other Jeffco cases?
And so I believe he has another Jeffco case that he has to be seen. When I try finding on the data access though, I can't find it. So I'm not sure if it's a muni or it's just entered in differently. But speaking with him, he says he has an upcoming Jeffco court date coming in November.
Okay. I guess if he doesn't have the Jeffco, if he doesn't have any Jeffco hold and the court orders that he serves this time, he might end up being transported here and then not being able to be in Jeffco for his cases.
Sorry, he would be transported here?
Because if he has time and not the credit, and he's not being held, then I don't know.
That he would miss and they don't have the writ for him.
Yeah, I don't know if then if he's not being held on a Jeffco, I don't know that I can authorize that he be able to serve it in Jeffco if he doesn't have anything pending with Jeffco.
Okay.
Let me just double check. I'm sorry, Deputy, you have the warrant served in this case on October 10th. Is that when? Okay, okay. Let me look. Mr. Aaron's, just one moment. The court is just wants to look. I guess I would ask you, are you being held on any Jeffco matters?
I have a court on November 7th at Golden, Colorado, yes. But there's no warrant or hold on me for that. They let me out so I can come up here and serve my time and get out and get back on the streets and then go back on the 7th up there. That's why I asked my lawyer if I could get some of my time knocked off for like my days that I still got left. If I could pay a fine, I got $1,000 in my bank account. I could pay the fine by the end of before Halloween.
Is he
If they didn't
single?
give me for the next 11 to 10 days and let me out today, that would help me out a lot so I could go back to ATOP through Denver Health. And then if you could impose a fine for the rest of the days instead of just giving me 30 days jail time, that would help me out a lot. But that's up to you. So I don't have any holds. I just got a court on the 7th of November in Golden, Colorado.
Judge, I did find a Jefferson.
And that's a misdemeanor.
Husband, go back to bed.
2500. It looks like an FTA warrant just issued on October 9th.
Okay, and that's out of Jeffco?
That is out of Jefferson, yes.
Okay.
It looks like it might just be how his last name's spelled in the Boulder case compared to that one, because it looks like the H and E, I believe, are switched in his name there.
Okay.
Or the R and the E.
Okay.
So that's why I wasn't able to find that.
Find it,
Yes.
perfect, all right. Let me see here, so that would be 11 days. So then he would be still appearing at Jeffco. I think that would be right. I'm just trying to think, can we confirm, how long he's been in Jeffco? Does it show when he was, arrested in Jeffco? No, I know from our cases, it wasn't until October 10th.
He was detained on September 26th, but posted bond on the 29th. So
And then I believe he
don't
went
see
to
that in
Denver
our case.
after that.
Yeah, after that, the next thing was the FTA warrant on October 9th. So I don't have anything in this Jefferson case in regards to him being in custody.
Mr. Zamora, we don't have, Mr. Aaron, hold on just a second. Mr. Zamora, we don't have anything that shows that he's in custody, so I don't think I can give him credit. If he was in fact in custody, I think the court could, but if we don't have anything showing, I don't think.
You don't have anything showing he's in custody? He's streaming from the Boulder jail. He's dressed in orange. He's literally physically in custody right now.
I can give him those 11 days.
Okay, so just the 19 that he does have when he has the arrest report. Okay.
Yes. We're trying. All right. Mr. Aaron, your attorney has told me that you have reached a plea agreement in this case. Is that correct?
Yes.
And thank you, if you can approach. Mr. Aaron, your attorney has signed on your behalf. And did you go over your rights and possible penalties?
Yes.
And do you have any questions regarding your rights or the possible penalties in these cases?
Nothing I can think of.
Okay. Are you under the influence of any drugs, alcohol, or medication that would prevent you from thinking clearly today?
I want to say that, no, maybe.
Are you under the influence of drugs, alcohol, or medication?
No.
Oh,
Just
okay.
medication.
Medication, okay, I see.
Move out of the way.
The medication that you are
Move
on,
over.
is it helping you to think clearly?
Yes, it does. It keeps the voices out of my head. I
Okay,
didn't understand what you meant by your card.
okay, so the medication you're on helps you to think clearly, so you're not you're not thinking clearly today.
No, I'm thinking clearly today.
Okay, thank you. Thank you for putting in that into a positive spin. Are you, is it anybody threatened you, coerced you, or forced you into taking this plea agreement?
No, they have not.
Okay, and you have a right to be here in person. You were appearing via WebEx when you were, do you waive your right to be here in person and agree that you want to take these pleas via video?
Yes,
Okay.
as long as I get the.
As to, go ahead. As to the charge in 25 M1108 to the count of public indecency, how do you plead, guilty or not guilty?
Guilty.
Okay. And as to 25 M1439, an added count 2 of unlawful use, how do you plead, guilty or not guilty?
Guilty.
Okay. The court finds that the pleas are voluntary, knowingly, and intelligently made. Mr. Zamora, waive a factual basis?
We'll waive, Your Honor.
Okay, the court will waive a factual basis. The court will go along with the plea agreements, and in 25 M1108, sentence you to 10 days of jail, give you credit for 10 days, and you will have no time remaining in that case. In 25 M1439, the court will sentence you to 30 days, give you credit for 19 days. There will be a remaining 11 days. The court will authorize you to be able to serve that in Jeffco. And the court will find that you are indigent and waive any remaining fees that the court is able to do. I guess, is there any restitution or cost of prosecution in either of these cases, Ms. Mason?
No, Your Honor.
Yes. The court's going to waive that drug offender surcharge. It was a DM2. Okay, Mr. Aaron, you'll have 11 days remaining to serve out this sentence, and it looks like if you have any other pending matters, you'll have to deal with that, but good luck to you, and your obligations for these cases will be done once you do that remaining 11 days, okay?
Is today one of those 11 days? You know when my release date will be?
It will be 11 days from now.
All right.
Okay? All right, thank you. Good luck. And then, we don't have to, do we have to do anything with this one? We'll need to reset it. Okay. Oh, it's sitting there. Okay, in 25 CR 1488, People v. Leonard McLankin, I believe that he's the one in the hospital? No, he's the one who did not get writ. He didn't get transported. We will ask for a Okay, so I think we'll probably have to set it for next, there's probably not a likelihood that we'll get him here. Okay, let's set this for next Tuesday, November 4th at 1:30 at the jail. Okay.
will, then we'll utilize Jeffco. Let them know that he's serving kind of future with that Jeffco.
Perfect.
So then won't arrest on that one.
Well, I think the issue is that they just have the name spelled wrong, and so I just don't think they're aware that it's the same guy in that case here.
No, he's recording.
Okay. Yeah, I don't know if that was something he had worked out that they told him to come back. That's just kind of what he told me, but then I just couldn't find the case until you saw that, so.
Right. Okay. Thank you. Thank you to the parties.
Thank you, Your Honor.
Thank you.
These judges are letting me down. This is a freaking... I recorded 11 hours of this, thinking it was a full day's docket, and it's just not. How did I get by with only working for an hour? Let's do... was from yesterday. This was just from yesterday. This is a YouTube judge. Not a not YouTube judge. Imagine that. Jeez, I don't even know how long this is. I should check. Alright, we got another plenty. That's how long it is. Oh, he talks a little slow, Judge Hart. I know you can't hear anything. I'm just setting it up. Okay. Now, when does he start talking? That's Favre, Joe Favre? Favre? Ah, come on, what is that attorney's name? We know him.
Yeah, and the court goes on the Zoom record. Case is entitled State of Kansas versus Savannah McElwain, 25 CR 293. State of Kansas appears by Assistant Butler County Attorney Brett Sweeney. The defendant, Ms. McElwain, appears in person and by court-appointed counsel Jorge De Hoyos. This matter does regularly come back before the court this date for arraignment. And once again, good afternoon, Mr. De Hoyos. Does your client wish reading of the charges against her?
That's not necessary, Your Honor.
And how does she wish to plead?
Your Honor, at this time, we enter a plea of not guilty.
Court enters a plea of not guilty and schedules this matter for, let me make inquiry as to how far out would you like this set? Would you like it set for December? I can do that if you wish.
Is that a firm trial setting, Judge?
Well, it's as firm as I could advise you of at this point in time. I don't know if there'll be more pressing case in regards to speedy trial or whatever, but that is the first available that I would have. And I don't, we'll try to get the case to trial as soon as possible.
Well, Judge, the reason I'm asking is because December is fast for the purposes that me and Savannah need to work together, but I have a baby due January 11th, so I'm probably into February for my trial dates.
So it'd be better to have December than
why
to
he's
have a January
glowing.
date.
Look at him glow.
It'd be better to have a February date, but if the court is going to insist on a December date, that's acceptable. That's fine, Judge.
No, that dude was... See, you're going along and you think you got it understood, but he just kept getting worse and worse and worse. That dude, Oh, when he said "my honey," I threw up in my mouth just a couple bits. He's gonna be a busy man. Yes, he's gonna be a busy man. He's a new father. Of course, he's gonna be busy.
All right. So the baby is due in January, and I think that probably the best alternative here would be to set the December date. We will try to get it to trial at that time. I can never guarantee much of anything in regards to a particular date, Mr. De Hoyos. Okay, the pretrial conference and plea docket would be set for December 19, 2025 at 9 a.m. December 19, 2025, 9 a.m. Jury trial would be January 9th, 2026 at 9 a.m. January 9, 2026 at 9 a.m.
Judge,
Subsequently, yes,
I'm sorry, what was the jury trial date?
I show jury trial date 1/9/26. That gets it past the holidays, I believe.
I think your jury trial date's the 12th.
Is it the 12th? Okay. Court stands corrected. The jury trial date would be Monday, January 12, Monday, January 12 at 9 a.m.
Judge, if everything goes right on my side, I should be a dad for all of 24 hours at that point.
Okay, good. Congratulations. So January 12, 2026 at 9 a.m.
I don't know if the judge quite understands what's going on here.
That's what you need, Mr. De Hoyos.
But no, I can't do January 12th at all. I'm gonna have to ask for continuance no matter what because the baby will do the day before that. So I'll end up in February, but if you want to wait to close to that date to schedule that.
The judge is like, "Why, you're not having a baby? You can come to work. What are you talking about?
Be it, Your Honor.
You're not even allowed in the room."
Okay. So we need to schedule this for pretrial conference in February and set it for jury trial in February, where that would be an alternate jury trial to the Greenwood County jury trial structure.
Yes, sir.
Is
And
that,
for
is that
the
what you
sake of
wish? Pardon me?
sorry, Judge, for the sake of timing, we would take all that time against the defense because it's me asking for the continuance.
Okay, the court notes that the court is ready and prepared to schedule this for January 12, I believe, for jury trial. The defense has requested continuance to February, and Mr. De Hoyos has advised that there's birth of his child that is imminent. So the court will schedule this matter for February. Pretrial conference plea docket, February 6th. And subsequently, we'll schedule the jury trial And Belen, do we not have a February jury trial setting?
Let me double check. I believe it goes out to March, but because we have Elk County, Greenwood, Elk County.
Okay, we'll set this matter for Tuesday, February 10, 2026 at 9 a.m. for jury trial. Tuesday, February 10, 2026, 9 a.m. for jury trial. This would be as an alternate to Greenwood and Elk County cases. The court would ask Belen to please note on the trial docket notes that the request to have this set out this far is the defense request, and the court grants the motion for continuance. So the time the court is finding, unless there's objection by the defense, from today until Tuesday, February 10, 2026, will be charged to the defense. Now, is that correct, Mr. De Hoyos?
Yes, Judge, and thank you for working with me, Your Honor.
Okay, that's more than agreeable. And all right, Miss McElwain, your next appearance date is by Zoom. It is scheduled for Friday, February 6, 2026 at 9 a.m. Your jury trial is scheduled for Tuesday, February 10, 2026 at 9 a.m. In the interim, the court does continue you on the bond that you previously posted. I do order you to stay in contact and communication with Mr. De Hoyos. Keep him advised all times, your current address, telephone number, place of employment, along with your bail bondsman. Anything further to come before the court, Mr. Sweeney?
No, Your Honor.
And Mr. De Hoyos?
No, Judge. Thank you, Judge.
And any questions, Miss McElwain? And you're on mute, Miss McElwain.
No, Your Honor, no questions.
There being nothing further, court is in recess. Miss McElwain, you're free to go. Have a good day. Mr. De Hoyos, you're free to go also. Have a good day. And request for next calling of case.
Judge, is it possible to take up my two? They're pretty quick, both of them.
Yeah, Mr. Favre, your client.
Miss Ogden first, please, Judge. Amanda Ogden.
Okay. Court goes on the Zoom record. Case is entitled State of Kansas versus Amanda Jewel Ogden, 25 CR 388. State of Kansas appears by Assistant Butler County Attorney Brett Sweeney. The defendant, Miss Ogden, appears in person and by court-appointed counsel Joe Favre. This matter does regularly come back before the court this date. This appears on the preliminary hearing control docket. And announcements to the court, Mr. Favre.
Judge, I have spoken to Miss Ogden and also Mr. Sweeney. At this time, we're actually going to request one continuance. I think this is our first setting on this matter. Mr. Sweeney and I are going to look at a possible resolution I think is is possible at the next hearing.
Thank you, Mr. Favre and Mr. Sweeney. Is that correct?
That is correct, Your Honor. Thank you.
And Belen, do we still have time available on the 12:15 preliminary hearing control docket?
Yes, we do, sir.
Thank you, Belen. The court schedules this matter for preliminary hearing control docket December 15, 2025 at 2:30. December 15, 2025 at 2:30. Ms. Ogden, the court does continue you on the bond that you have previously posted. I do order you to stay in contact and communication with Mr. Favre. Keep him advised all times, your current address, telephone number, place of employment.
Yes, sir.
Any other matters to come before the court, Mr. Sweeney
No, Your Honor.
and Mr. Favre?
Not at this time, Your Honor. Thank you.
Ms. Ogden, any questions?
No, sir.
There being nothing further to come before the court is in recess. Ms. Ogden, you're free to go. Have a good day.
You too. Bye.
And Mr. Favre, your next case?
Judge, we have Mr. Michael Graham, who I think is here for a bond revocation.
Court goes on the Zoom record. Case is entitled State of Kansas versus Michael Graham, 25 CR 290. State of Kansas appears by Assistant Butler County Attorney Brett Sweeney. The defendant, Mr. Graham, appears in person and by court-appointed counsel Joe Favre. This matter does regularly come back before the court. This is set on the preliminary hearing control docket. And announcements to the court, Mr. Favre.
Judge, I think the main reason we're here is because the state's filed two motions to revoke Mr. Graham's bond based on affidavits filed by CSO Bauer, who's present.
Thank you, Mr. Favre. And motion to revoke bond, Mr. Sweeney.
Yes, Your Honor. I don't know if the court wants to hear evidence, but I believe we have 3 witnesses here in support of the motion to revoke bond. Officer Penland with Greenwood County Sheriff's Office, Officer Fletcher with EDPD, and Mr. Bauer. If the court would like me to, I can just go ahead and submit testimony through those individuals at this point.
And Judge, I think just to make it quicker, Mr. Graham will stipulate to the fact that he missed at least one, if not more meetings with Mr. Bauer. He says it was at least one. He also will stipulate to having been arrested in Greenwood County, but that case is brand new. He hasn't even had his first PHC docket on that yet. So he would stipulate to having been arrested in Greenwood County while on bond. He would also stipulate to let me see, what was the other one? But he would stipulate to at least those 2 allegations that are being alleged by the state.
Thank you, Mr. Favre and Mr. Graham. Mr. Favre, it's advised. Pardon me?
Yes, sir.
Mr. Graham, Mr. Favre has advised the court that you do wish to admit to being in violation of the terms and conditions of your bond. Is that correct?
Yes, sir.
You understand by making this admission, the court could very well revoke your bond and order you to the Butler County Jail. Do you understand that?
I do, Your Honor.
Have you had adequate and sufficient opportunity to confer with Mr. Favre prior to admitting to the bond violations herein?
Yes, Your Honor. Briefly, we have.
Do you wish further time to talk with Mr. Favre?
I would like to request if I could maybe have an ankle monitor, and I got a good job, Your Honor. I just started, and my wife's on Social Security. I did go down the wrong road, and I missed some meetings, and I was off track.
Michael,
I'm on track now. I got a good job.
Michael,
Yes, sir.
you already talked to me
Yes,
about
sir.
that, and that's not what Judge asked. Judge asked if you want time to talk to me, not do you want time to explain things to the court.
Oh. Yes, sir. I would like to have time to talk to my attorney, please.
Court will take a recess, and there'll be a breakout room established for Mr. Favre and Mr. Graham.
Thank you, Your Honor.
Judge, I wanted to let you know his bondsman, Mr. Kirkman's also present here too.
Thank you, Al.
You're welcome.
Judge, I just have a couple of requests for continuance, if you would take those up. And the reason why I'm asking is one of my clients, Ms. McKendry, is feeling pretty under the weather today and trying to get her released if possible, as quickly as possible.
Thank you. Do you wish to take up her case first?
Yes, please. Heather McKendry. She has 2 cases, Judge.
Thank you. Court goes on the Zoom record. Cases are entitled State of Kansas versus Heather Diane McKendry, 24 CR 494 and 25 CR 219. State of Kansas appears by Assistant Butler County Attorney Brett Sweeney. The defendant, Miss McKendry, appears in person and by court-appointed counsel Blake Cooper. These matters do regularly come back before the court this date on the preliminary hearing control docket. An announcement to the court, Mr. Cooper.
Judge, I'm asking to move these 2 cases, hopefully just one more time, working with Mr. Sweeney on trying to get these resolved. I do believe they will be resolved without trial.
Court makes inquiry if Miss McKendry is present on the Zoom hearing today.
Yes.
She is. I'm sorry, Judge. She's under Cooper law.
Thank you. And Miss McKendry, excuse me, Mr. Sweeney, do you have any objection to these 2 cases being continued into the future, which the court would anticipate using the December 15, 2025 date?
Your Honor, state has no objection to that, and I'm assuming that's the next PHC date.
Yes, it is.
No objection, Your Honor.
All right. The court does grant the motion for continuance by the defendant. Court does schedule this matter for reschedule this matter on the preliminary hearing control docket, both cases, and that would be for December 15, 2025 at 2:30. December 15, 2025 at 2:30. Ms. McKendry, you do need to be present by Zoom process, either at the Butler County Judicial Building or at Mr. Cooper's office. The court does order you to stay in contact and communication with Mr. Cooper and your bail bondsman. Keep them both advised all times, current address, telephone number, place of employment.
Yes, Your Honor.
Anything further, Mr. Sweeney?
No, Your Honor.
And Mr. Cooper?
No, Your Honor. Thank you.
And Ms. McKendry, do you have any questions?
No, Your Honor.
There being
Thank
nothing
you.
further, court is in recess. Ms. McKendry, you're free to go. Have a good day.
Well, Lynn,
And
I think he may need help coming back from the breakout room.
And Judge, my other case is Jesus Reyes.
all right, is Jesus Reyes? Yes, he's present. I show him. Thank you.
Jesus, turn on your camera, please. Thank you.
Irish, you're green. Green. Look at you go. I'm on Twitch. So speaking about
Jesus, can you
Twitch,
straighten out the camera?
yo, I'm speaking right now, sir. Man. Speaking about Twitch, if you are watching my live stream, this only counts for live streams. So it won't help you if you are on replay crew. I'm so sorry. I'm so sorry. Wait, maybe it... Okay, maybe it will. Maybe it will. So, if you have Amazon Prime, right, then you get a free subscription to one Twitch channel every month. But you have to subscribe every month. Like, it's not automatic. And if you're watching my live and you do not have YouTube Premium, and you get ads and they're annoying, then you can just use your Amazon Prime membership to link to Twitch, and then use that one free subscription to subscribe to this channel, and then all of my live streams are live, like you can see right here. You can see the Twitch chat. They're live on Twitch, and you can watch the same stream there, and you can chat right here. Like, you guys can see what I'm pointing at. You can chat. Everybody in YouTube can see your chat. But then you don't have to watch the stupid ads. So, if you have an Amazon Prime membership, link it to your Twitch and subscribe to my channel on Twitch. And you know how I said this won't help replay crew? Yes, it can. If you're watching ads and you watch it on Twitch as a sub, you will. I have them saved, like the last 5 saved on Twitch or something like that. Then you can watch it for there, or you can replay there for no ads. Just a thought. Just, you don't have to. I'm not asking you. I am not asking you to become a sub on Twitch. All I'm saying is if you have ads and you don't want to see them, then you can do that. It's an option.
So we can see you. Thank you.
Santa?
okay, and it's actually Jesus Adam Botella Reyes. Okay. Court goes on the Zoom record. Case is entitled State of Kansas versus Jesus Botello Reyes, 23 CR 81. State of Kansas appears by Assistant Butler County Attorney Brett Sweeney. The defendant, Mr. Botella.
Mister, he's too young to be a mister. Look at that. How old is he?
Reyes appears in person and by court-appointed counsel Blake Cooper. These matters do regularly come back before the court this date on the preliminary hearing control docket and announcements to the court. Mr. Cooper.
Your Honor, I would request another continuance of the PHC at this point, maybe to that December 15th docket. I'm working on, we've been trying to get Mr. Reyes into my office. He needs to review a video that I have, and we're trying to get him in. He's had a few transportation issues, but
From school.
I'm hopeful to get him in the next week or so.
All right. Okay, any objection to the proposed continuance motion, Mr. Sweeney?
Again, Your Honor, no objection.
Court does reschedule this as long as I don't hear that our December date is full. B for preliminary hearing control docket, December 15, 2025 at 2:30. December 15, 2025 at 2:30. Court does grant the motion for continuance, and the time will be charged to the defendant. Court continues the defendant on bond previously posted and does order Mr. Reyes to stay in contact and communication with Mr. Cooper and your bail bondsman. Keep them both advised all times, current address, telephone number, place of employment. Any other matters to come before the court, Mr. Sweeney?
No, Your Honor.
And Mr. Cooper?
No, Your Honor. Thank you.
Any questions, Mr. Reyes?
No, Your Honor.
There being nothing further to come before the court, court is in recess. Mr. Reyes, you're free to go. Mr. Cooper, anything further?
No, Your Honor. Thank you very much. Appreciate it.
Have a good day.
Thank you, Your Honor.
All right, and we're ready to go back, Mr. Favre, to your case.
Thank you, Judge.
Court goes back on the record in case entitled State of Kansas versus Michael Graham, 25 CR 290. Once again, state by Mr. Sweeney. Defendant, Mr. Graham, appears in person, and by Mr. Favre. Also appearing at this time is Court Service Officer 2, Tony Bauer. And once again, announcements to the court from Mr. Graham.
So, Judge, we've already previously stipulated to the allegations, and Mr. Graham had wanted to ask me a personal question, which I answered. So I think we're ready for recommendations.
Thank you, Mr. Favre. Is that correct, Mr. Graham?
Yes, Your Honor.
Thank you. And recommendations in regards to bond?
I just redid my whole Twitch stream because you said my Twitch wasn't updating and it was just my chat that wasn't updating. But it's okay. They're both good now. Both of them.
Mr. Sweeney.
Your Honor, so just to recap the state's motion to revoke bond, and
Oops.
I guess I didn't know that I was clear on 100% what all had been stipulated to, but we have alleged that he had the new arrest over in Greenwood County. He has a new criminal trespass let me make sure. I think it's a criminal trespass case. That's correct. On the Bumgars that is alleged to have happened here in Butler County on September 25th of this year. That's been filed in 25 CR 471. And then we have the case here today that's we filed a motion to revoke bond on. So essentially, he's got all these retail theft situations going, and he's not reporting to Mr. Bauer. Our request is that his bond be revoked, and at a minimum, the cash amount be raised to a significant amount higher. We were thinking somewhere in the neighborhood of $50,000 cash as surety. Additionally, we were wanting GPS on Mr. Graham. We believe that he is kind of working with a couple of other individuals by the name of Sater and Moore that are part of this crew. We're asking for a condition of no contact with those individuals as a condition of this bond, and then also a that if he does make bond, that he be
Bobby.
outfitted with a GPS device so we know where Mr. Graham is at.
Thank you, Mr. Sweeney. The individuals that you're asking no contact with are Mr. Sater, and what's the other name?
Mr. Moore.
Mr. Moore. And the proposed new bond is $50,000 cash or surety.
Yes, sir.
Yes, sir.
Okay. And with GPS ankle monitor.
Yes, sir.
Okay. And further recommendations from the court service officer, Mr. Bauer.
Your Honor, I would agree with the state's recommendations. My concern here is he's picked up several new cases, and he told me this case was going to be resolved, but then it got continued because he picked up a new case. If he continues to pick up new cases, it's just going to continue to delay the cases he has getting done. So that's my biggest concern with him. And then I believe that the Moore that Mr. Sweeney was referring to is actually a Miss Moore.
Oh, okay. Thank you, Mr. Bauer.
My mic is on. Oops. Wait a second, sir. If he picks up one case, isn't the terms of that one case is do not pick up any more cases? So if he picks up a case, after that one case, then he should be revoked, right? So he can't pick up any more cases because he would be incarcerated, right?
And thank you, Mr. Bauer. And recommendations from defense, Mr. Favre.
Judge, obviously, we don't want to comment too much on pending criminal matters. We point out that the matters that are discussed that he stipulated to are the Greenwood County felony case and the Butler County criminal trespass misdemeanor case, both of which are still pending. He wants to come forward and say he screwed up, he made mistakes by not reporting and doing and having this law enforcement contact, but we don't want to discuss the details of these cases too much. But needless to say, there's a lot of details involved in the allegations in both these matters. Mr. Graham, coming into this, we were hoping to have a resolution. He has made that more difficult with his new cases, but he has managed to secure a brand new job at Atlas Aviation Manufacturing. It's a very good job, and he's hoping to not lose that bond. If his bond was revoked and he was asked to pay a bond in the amount of $50,000, he would surely lose that employment, which is really very helpful to his house. His wife is on disability, and they're the only two in the house. He cannot support his household as it is, and so we're asking the court. He has told me he does not mind doing GPS, house arrest, work release. He really doesn't want to lose his employment. We would ask the court to consider a bond modification and raising it, but $50,000 from where it is right now, $2,500 is just a really high jump. So we would ask the court to consider setting it somewhere in the neighborhood of maybe $7,500, but with a GPS requirement, an ankle monitor, so that he can continue that employment and continue reporting to Mr. Bauer. And so that is our request at this time.
Thank you, Mr. Favre. The court does revoke the current bond on Mr. Graham. The court does order $50,000 cash or surety bond with GPS ankle monitor. Subsequently, the court does reschedule this matter for pretrial conference plea docket December 19, 2025 at 9 a.m. with jury trial commencing January 12, 2026 at 9 a.m. Any other matters to come before the court? Mr. Sweeney?
No, Your Honor.
And Mr. Bauer?
I have nothing further at this time, Your Honor.
And Mr. Favre for the defense.
Yes, Judge, we had raised the issue of if the court's going to modify the bond, consider allowing him to do the bond on house arrest or with an ankle monitor. As we noted, he does have this employment doing aircraft manufacturing for Atlas. We'd ask the court to consider granting work release or house arrest with the increased bond the court has already ordered.
Thank you, Mr. Favre and Mr. Sweeney.
Your Honor, the state would object to that.
Mr. Bauer,
Your Honor, I don't know that house arrest would really make much of a difference than him being on a GPS when he bonds. So I don't know that there's really anything for me to say about that.
Give him work
thank you,
release.
Mr. Bauer. The court overrules and denies the motion for house arrest. And subsequently, Mr. Graham, the court does order you to report to the Butler County Jail, and that would be by 3 p.m. tomorrow. 3 p.m. tomorrow.
I don't know. I wish he would have gotten work release so he could keep that job. Well, I guess. So the one time no one knew I was coming until the very end, till I was like on my way. I went twice. And I mean, I spoke to her every day. She was my mod, so I did tell her. I didn't make advance arrangements. I was just talking to her. You know, I'm gonna be there. I'm gonna be there. Lots of people remember. I can't remember his name. Red. His name is Red, I think. He showed up out of the blue and was just watching, and then he went up to see them after the docket was over. He went up and, you know, he's like, I'm Red. And I think Donald went once, and he went up at the end. They didn't know. But you don't have to make arrangements. You can just, you know, talk to them when you get there. It's open. I mean, it's an open court. So, or you can. I mean, Victoria's email is on the website, so you can just send her an email.
Any other matters, Mr. Sweeney?
No, Your Honor.
Mr. Favre?
No,
Not this time, Your Honor.
And Mr. Bauer?
At the end, then they fall asleep, and then never mind.
I have nothing for you.
There being nothing further to come before the court, court is in recess.
Okay, so are we in recess? Court Vibes is in recess. He does recommend visiting on a Friday because it's the best day. Although I thought Mondays were the best day. I mean, we recorded him for a while, and I thought Mondays were way better than Fridays, but that was just me. Anyway, thank you guys so much for coming out today. I appreciate it. I'm going to start OJ, and then I'll see you again very soon. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. her joy she can't hide.